This is copyright 1, part 3. And in this capsule, we're going to look at the last two elements that we just mentioned in the previous capsule, and that is fixation and originality. So fixation is, well, it's not clear what it means, right? That's the point of the section. It's a requirement that something be fixed into a medium. And there's no general requirement in the Copyright Act of fixation. However, as we said earlier, since copyright law doesn't protect ideas, there kind of is a requirement of fixation, if you call it that or not. Because my ideas are not protected, they're only protected when they're turned into a book, right? Or a CD or whatever it is. And so whether or not we call it a fixation requirement, there kind of is always such a requirement. And as we're told, there are some specific sections in the Act that do require fixation by name, most notably for video work, movies generally. And of course, that leads to all sorts of questions about whether that's kind of a different fixation requirement or not, and if the Parliament is assumed to have thought this true and use the word for a reason, and for them to state that there is a specific fixation requirement makes it confusing as to whether there can be a general requirement of fixation. But all that is kind of way beyond the scope of our discussion here, and you can kind of assume that there is a fixation requirement of some sort for everything, because something that is not fixated is often just an idea, and as we said, ideas are not protected. And so we have the Gold case on fixation. Basically, someone famous, and then someone takes pictures of them, records them, and then eventually creates something out of that and makes money with it. The facts are not all that important here, but basically the conclusion is that in some way fixation helps us understand what is and is not protected. And in the case here, right, the recordings and the photos are not the kinds that are fixated generally to make money, right? It's not a song that was recorded specifically to be told. It's just kind of a conversation that was recorded, and that's even though it's fixated, is not really the kind of thing that is usually the subject of protection. And so the person that makes the transcription of the conversation, the person that, let's say, they transcribe the discussion from, if that person doesn't consent, they can't really contest it, at least not directly. And then the second conclusion is, if we take such public discussions and then make something with it, that something can be protected. For instance, a book. And again, we're told that it would be a problem if all conversations were the subject of protection, because that would be too broad and restrictive to what people generally can do. And again, we're told that this doesn't really affect, as one party had contended, the artistic nature of work, because this is not like appropriating someone's, verbal product that is produced for artistic commercial purposes. It is simply taking their conversations that were made basically with the expectation that it would eventually make its way, or may make its way, into the public domain. Second, we get this idea of originality in much greater detail, and that is a statutory requirement, right, in Section 5 of the Copyright Act, which says, well, copyright exists or subsists in every original literacy, dramatic, musical, and artistic work. Again, the adjective is original, and that is defined elsewhere in the Act. And this idea of originality was taken up by the Supreme Court of Canada in the CCH Canadian Limited versus Law Society of Upper Canada case, which we'll just call the LSUC case, Law Society of Upper Canada. Basically, this library had this tremendous service where, you know, instead of you using a photocopying machine yourself, they could do it for you and send it to you. And then they did that. And then the issue was, again, the facts are not particularly relevant to the principles that are stated in the case, especially not in the version you have. The issue was basically, what does originality mean? Because what was reproduced was judicial decisions. And then we had this clash of approaches between of what originality means. The first one being this approach from the United States Supreme Court that something has to be new to be original. It has to be like, you know, groundbreaking stuff that was invented and that was not known before. It's a concept that we have elsewhere in intellectual property law, most notably in patents, right? To get a patent, which is arguably has much stronger protection because it gives you a broader monopoly and for a longer period of time, generally speaking. You have to have invented something that is new, right? That's the approach from the United States Supreme Court. Second approach is, well, it's all about the work you put into making something. So as long as you put some work into making something, even if it's not new, what matters is you put some work into it. And then the Supreme Court says, well, these two things are both wrong. And it kind of is a combination of the two, right? So the work you put into it matters, but not in and of itself. And it has to be new, but not really that new. And that's illustrated later on in the case. That's the standard that's defined by the Supreme Court, essentially, you know, sui generis, brand new in that case. The court uses various methods to come to that conclusion. What's important before we move on, though, is that when we're talking about, you know, the original aspect of it, the creative aspect of it, we're talking about, and this is a distinction that is hard to make sometimes, I admit, but we're talking about the original aspect of the work, right? So not the original aspect of the idea as expressed in the work, because again, I've repeated it on and on, ideas are not the subject of copyright protection. So it's really the making of the work itself, which have to be original. And so once the court makes that distinction, we have some an interesting example is applied to the facts of the case, which are judicial decisions. And we have basically various sections of a judicial decision, which I will explain in case you have not encountered them in your academic career. And so we have the head note, right, which basically summarizes the case, usually with mention of the important principles, labels, and then dashes. Then we have the case summary, which is the summary of the case. And then we have the topical index, which is basically, putting the decision under the right, fields or areas of law and concepts. And then we have the decision itself. Of course, coming up with a decision that and writing it down, right, leads to a work that is copyrightable for the judge or whoever, in that case the law says holds a copyright for the judge or assigns it or whatever. The activity itself of creating the decision creates a work that is copyrightable. Then the court says, well, everything else also is copyrightable. So the head note is original enough. And this gets back to this standard of originality, which we said, the court essentially defined in that case, saying it has to be original, but not that original. That's as best as I can express it. And the court, uses this as an example. So the head note, obviously you take stuff that's in the case, but you arrange it differently for people to find the case. Well, that, the court says, is original enough. And even perhaps more surprising, the court says, well, the summary of the case is also original enough, because someone had to decide, what to include, what not to include, what was important, what was not important, and that is enough of an effort yielding an original work for the work to be protected. And then the court says essentially what I just said about the topical index as well. The skill and effort to categorize stuff also has enough of an original aspect to it to trigger the protection. Regarding the decision itself, the court says basically what I said before. The judge or the person creating the work has created a work that is copyrightable, that is true. But the reporter, right, the company that takes the case and publishes it, that's how it used to be, and to a large extent still is, right? We have reporters, and so the court, renders a decision, and then someone puts all these decisions together, which are usually freely available, and then puts page numbers on them, and then, proceeds to sell this stuff. And the court says, well, the decision itself is copyrightable for the person that makes it, right? But the fact of arranging the decision into a reporter is not original enough. So putting the page numbers on it is not original enough to trigger the protection for the person arranging the work.